docket. It's case number 112169 in the matter of Andrew M. Delaney.
Good morning. May it please the court, counsel, Deborah Hughes, Deputy Disciplinary Administrator on behalf of the Disciplinary Administrator's Office. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
This is an original action involving attorney discipline. It's before this court after a hearing panel heard evidence on May 6th of this year. The panel heard evidence on a complaint charging violations of the Kansas Rules of Professional Conduct. The respondent admitted those rules violations, and based on the admissions and the stipulated evidence, the hearing panel found that the respondent had violated KRPC 1.3, diligence, KRPC 1.4, communication, KRPC 1.8E, conflict in providing financial assistance to a client, KRPC 3.2, expediting litigation, 8.1B, and Rule 207 for failure to cooperate. The respondent has not filed exceptions, and therefore the primary issue before this court is what is the appropriate discipline. Just by way of a very brief background procedurally, this case is comprised of 3 different cases, 2 diversion revocations, and then a third case in which the underlying complaint was found by the review committee to not be supported by probable cause. So the third complaint is before the hearing panel and then before this court solely on the respondent's failure to provide a timely written response to the initial complaint that was filed by the complainant in that case. The recommendation before the panel made by our office was that the respondent be suspended for a period of 6 months and that the court adopt the respondent's probation plan and place him on a 2-year probation. The hearing panel adopted that recommendation. That was joined by the respondent, and the hearing panel adopted that recommendation and makes that recommendation to the court. The probation plan includes a number of specific terms and conditions that are set out in the final hearing report of the panel, and this office is in agreement with each and every one of those conditions. Those conditions largely followed the respondent's proposed probation plan that he had implemented and was following at the time of the hearing as required by Supreme Court rule. So our recommendation before the court today is the same as it was before the hearing panel. We recommend that the court follow the panel's recommendation and adopt the probation plan that's set out in the final hearing report. We believe that the panel's recommendation is warranted in this case for a number of reasons. First, under the ABA standard, suspension is the presumptively appropriate discipline in this case for these types of violations. Second, we believe probation is appropriate and warranted in this case under Supreme Court Rule 211G3. There are 4 factors that are set out in that Supreme Court rule for a probation plan that make probation an appropriate disposition in a case. The first is that the respondent provide a timely, workable, substantial, detailed probation plan, and that has been done in this case. Second, that he has put the plan into effect before the formal hearing and that he is complying with each of the terms and conditions at the time of the hearing, and that was complied with. That he has continued to comply with the hearing panel's probation plan from the time of that final hearing report through today. We have been provided a number of updates and status reports as required by that plan, proof that he's paid restitution, the audit and quarterly report by his practice supervisor. All of these have occurred since the entry or the filing of the final hearing report. His psychologist has filed a status update with our office. KLAP has filed a status update with our office, all of which show that he is continuing to successfully work his probation plan that was set out by the hearing panel and as he had proposed. The third factor for diversion or for probation is that the misconduct can be corrected by probation. And this is classic conduct that falls within probation. It doesn't involve dishonesty or fraud in any way. It's simply a lack of diligence, delay, failure to timely respond, and the respondent was under an undiagnosed and untreated condition of depression at the time for which he is now receiving treatment. So it's particularly amenable to probation, this type of conduct. And last, the fourth factor is that the probation is in the best interest of the profession and the citizens of Kansas. Of course, the respondent will speak to this in more detail, but just the evidence at the hearing showed that he had 12 years of experience in practice at the time of this misconduct. He enjoys the respect of his colleagues. He was suffering from a mental health condition at the time that was contributory to this conduct. And there was evidence presented at the hearing about how valued his representation is and the type of work that he does up in the Brown County and Donovan County areas where he practices. He does a lot of court-appointed work and is the go-to person when other attorneys that are typically appointed in the cases that he handles are conflicted out. The courts go to him. So the last condition is that it's in the best interest of the citizens of Kansas. This probation plan is designed to restore him to a capable, fully functional practicing attorney, and in that sense it's in the best interest of the citizens of this state that he be permitted to continue to successfully work this program and complete it. In short, we are making this recommendation today because our office has confidence that he will work this probation plan successfully and that in doing so it will correct the problems that brought the respondent here. If we are wrong, the insurance for that is the 6-month suspension that is suspended pending the completion of that probation plan, the successful completion of it. And so we believe that it's in the interests of the public and the respondent and the citizens of Kansas to adopt the probation plan, impose a 6-month suspension, suspend it, and allow him to work that probation plan.
Ms. Hughes,
Yes.
on the suspended suspension, have the parties contemplated at all if that should at some point need to be imposed? Would a reinstatement hearing be required? And if so, what kinds of evidence would we need?
I don't know that that was contemplated. I know that Mr. Slinkard, who handled this case before the hearing panel, said that he would have recommended a 6-month suspension with a 219 hearing, but for the respondent's demonstrated efforts to correct the situation.
It may not have been contemplated by agreement, but it was voiced by the disciplinary administrator's office at the hearing. Okay.
Yes.
Thank you.
If there are no further questions, we'll request that the court adopt the panel's findings and conclusions and impose the recommended discipline.
Any questions? Thank you, counsel.
May it please the court, J. David Ferris appearing for the respondent, who would also like to make a statement to this court in a few moments. I point out to the court that there are 3 other people in the audience who are not entering their appearances but are here in support of Mr. Delaney. 3 of those people that testified at the disciplinary hearing: Mr. Kevin Hill, who is the county attorney in Brown County and works with Mr. Delaney on a weekly basis; Mr. Charles Baskins, who is the county attorney in Donovan County, who also works with Mr. Delaney on a regular basis; and finally Mr. William McClellan, who is the practice supervisor and who is weekly in contact with Mr. Delaney to ensure that the probation plan is followed to the letter. I can't say very much, Your Honors, other than the disciplinary administrator has been extremely gracious. We've worked together since we filed the original probation plan in December of 2013, and through the assistance of Mr. Hazlitt's office, we have condensed that plan, modified that plan, and made it a workable plan, which Mr. Delaney has been operating under since April of 2014. The reports which the court has in file and the disciplinary administrator spoke to from KLAP, and Mr. Maxwell, the psychologist, show, I think, the progress that Mr. Delaney's made during these proceedings. As the disciplinary administrator pointed out, the mitigating factors that the panel found in this is there was no dishonesty. He was suffering from severe, at the time of the act, undiagnosed depression. There were 4 that he found, and I beg your pardon, that the support that was shown by his peers, and although he failed to cooperate initially, he cooperated fully at the disciplinary proceedings and admitted his wrongdoings. The one thing that I think stands out in this case is at the time this complaint arose, Mr. Delaney was within 1 payment and 1 month of completing his diversion agreement. The letter came, and as he testified in front of the hearing panel, he set it on the corner of his desk and looked at it every day and could not open it. And that's, as the disciplinary administrator pointed out, is the reason we're here today. Had he opened that letter, had he replied to it, because the complaint was found not to have any merit, we wouldn't be here. Hopefully that you will follow the recommendations of the panel. I'd stand for any questions, Your Honor.
Any questions?
I think following up on Justice Byers' question, it's probably a pretty good catch that, assuming we go with the recommendation, we do have to fashion an order that says that the 6-month suspension is suspended. And so what happens if we get into a situation where it has to be invoked? Would you agree that a reinstatement hearing at the end of the 6 months probably is appropriate?
Absolutely, absolutely.
Any more questions? If not, we'll be pleased to hear from your client.
Thank you, Your Honor.
Good morning. May it please the court. Thank you for allowing me to address this court, and I would like to apologize for any inconvenience my actions have caused this court. I would like to apologize for any inconvenience and extra work that I caused to the disciplinary administrator. I am sorry that people are or have been adversely affected by my actions. And while I'm well aware that no attorney likes to be facing disciplinary action, my involvement with the disciplinary administrator has been very much a blessing in disguise. During the investigation of my case, Ms. Knoll from the disciplinary administrator's office made contact with Ann McDonald from the Kansas Lawyers Assistance Program. She made contact with me. Through my contact with KLAP, I was referred to a psychologist. I met with a psychologist. At some point after my therapy began, I contacted my primary care physician who prescribed me an antidepressant medication. So although I couldn't see it, I can see it now with the benefit of the therapy and the medication in hindsight that when the complaint was filed and for quite a period of time before that, I was exhibiting some pretty classic signs of depression. I couldn't see it at the time, but these 4 individuals could obviously see that when I had contact with them. And I don't want to be over dramatic, but I think I was tumbling down a pretty dark spiral at the time that a disciplinary administrator made their initial referral to KLAP. And that referral actually probably saved me from falling all the way down. And I know it saved me from some pretty significant trauma. It saved my family, and I think it's led to a better practice of law. So it's my sincere hope that Ms. Hughes will pass that message along to Ms. Knoll. But in addition to the improvements I've made in the mental health, Mr. McQuillan and Mr. Ferris have made recommendations. They've assisted me in modifying my office practices, and we're set up so that a situation like this won't occur anymore. We have a better calendaring system. We have a better system for tracking and monitoring the cases. Mr. McQuillan checks in with me very frequently to make sure the cases are being met. So it is my belief as I stand here today that I am in a much better position to practice law than I was when the complaint was originally filed. I feel organized and I feel capable. And I believe that with my continued involvement with KLAP therapy and medication, I'll further improve my ability to practice law. Regardless of what this court decides on my case, it's my intent to continue with all of those. But I am confident now that I can fulfill the obligations of that probation plan that's been outlined by the hearing panel. I'm confident that I can continue to assist my community with its legal needs for much time to come. And what I would like for you to do is give me that chance. I don't have anything further. I know it's been a long week, but I'd be happy to answer any questions you might have.
Do we have any questions of council? I see none. Thank you.
Thank you.
You reserve 3 minutes for rebuttal.
Unless the court has any further questions, I'll waive rebuttal.
Any questions? Thank you all for your arguments this morning. Court will take this matter under advisement.